Right, it's 12:03. I think we will get started. Hi, everyone. My name is Andrea Marson. I'm an Equal Justice Fellow at Maryland Volunteer Lawyers Service in the Elder Justice Program. I started this job in July. It's a 2-year fellowship. And one of the primary concerns I've had working with this population is how can we make sure that we are honoring and respecting our clients' autonomy and making sure that they're in control of their decisions. So capacity is something I've sought to learn a lot about. And one of the people who's aided me in that search is David Godfrey. And he's at the ABA. I've had the pleasure of attending a few webinars by Mr. Godfrey. He is a senior attorney at the ABA Commission on Law and Aging in Washington, D.C. He's responsible for the ABA's role in the Administration on Aging funded National Center on Law and Elder Rights, NICLR, and they also run a lot of great trainings. Prior to joining the commission, he was responsible for elder law programming at Access to Justice Foundation in Kentucky. Mr. Godfrey earned his BA with honors at Rollins College in Winter Park, Florida, and his JD cum laude at the University of Louisville School of Law in Kentucky. He served on the board of the National Academy of Elder Law Attorneys, and in 2019, he was named a fellow of the Academy. Thank you so much, Mr. Godfrey, for presenting on understanding and enhancing client capacity. If you have any questions during the presentation, feel free to put them in the chat. There will be some time at the end.
Okay, thank you. It's my pleasure to be here this afternoon. So understanding and enhancing capacity. Starting point is, what's capacity? Capacity is the ability to make an informed choice or decision, to give informed consent. We think of capacity as a spectrum. About 20 years ago, there was a shift from competency to capacity. Competency was seen as an on-off switch. You had it or you didn't have it. You're competent to stand trial or you're not competent to stand trial. And that's still a standard that's used in that type of a decision. But legal decision-making ability is really a capacity, and it's a spectrum from genius to comatose. We're all someplace on that spectrum. Hopefully we're closer to genius than we are to comatose, but we'll all be there, and we'll vary from time to time and place to place. Capacity is also situational. What are you asking the person to do? I can drive the pretty little red car, but I probably can't pilot the Zeppelin. At least not without a lot of help. And we'll talk about help and supporting people in decision making and supporting people in capacity, because we can get a lot more done with a little bit of help. But one of the first questions in capacity is always capacity to do what, because it's very situational. Capacity is also transient. It comes and it goes and it can come back again. It's not a constant. Capacity is impacted by a variety of things: illness, pain, lack of sleep, medication, substance use or abuse, stress, the time of day, grief, depression, and mental health. And when we're working with vulnerable populations, these are things that we always want to be aware of. What's happening in this person's life beyond the legal question and the facts and the question that we're being asked. The guy in the chair with the goofy grin on his face is me. A couple of days after some significant surgery, and there was good news and bad news. The good news is the pain medication was incredibly effective. I only had one time when I had to say, give me more pain meds. The bad news is they gave my phone back to me the second day, and I started sending text messages, and you go back and read those and something was impacting David's ability to be rational, logical, make good decisions, communicate clearly. When the pain medication went away, the capacity came back. But we always want to look at medication, substance use and abuse, lack of sleep, just this list of mitigating factors, because anyone is capable of having a bad day, and on a bad day, it will significantly impact our decision-making ability. A threshold for us is always hiring a lawyer. Can the client engage the lawyer for their services? And then does the client have the capacity to complete the transaction? That's a second question. So for hiring a lawyer, can a lawyer engage us? Does the client know they have a legal problem? The problem they have, what's bothering them, is a legal problem, that you're a lawyer or a legal advocate and you could help them and that they want you to help. If those three elements are met, you should be able to argue that your client has the capacity that's necessary to enter into an attorney-client relationship. If the client is unable to determine whether it's a legal problem or not, or unable to be clear of, I have a legal problem and I want you to help, then you have a challenge should anyone challenge your representation of a client. And who's going to challenge that? Opposing counsel, judges, but even a person who's under guardianship or conservatorship may very well be able to go, I've got a guardian or conservator. I don't think I need one. You're a lawyer. Can you help me get out of this? And if you can get that testimony to a judge should be able to recognize that the client had the capacity to know that they had a legal problem and that you're a lawyer and that they want you to help. Then comes a more complicated question of, do they have the capacity to complete the transaction? And we'll move through that. And here we start talking about specific legal standards of capacity. Probably the oldest classic is testamentary capacity. Always loved the ancient English common law phrase, the natural objects of their bounty. Does a person executing a will know who they are and who their family is, the nature and extent of their property, that the document they're signing is a document that's going to create a plan for distribution of their assets at the time of their death? Because those are the elements, and some states have put this into statutory law, but in a lot of states it's still in case law. Testamentary capacity is actually a relatively low standard, and yet you do see estate planning that's challenged based on lack of testamentary capacity. A lot of statutes or a lot of stock will forms still use the term of sound mind, but if you look in the case law, you won't find sound mind defined as well as you will testamentary capacity. Power of attorney, we do a lot of planning for incapacity work, a lot of power of attorney work. And the capacity to execute a power of attorney in most states' case law is based on the capacity to contract, because the power of attorney is really a contract appointing an agent to act on behalf of the grantor. Some courts and some case law hold that it's a standard more similar to that of making a will. As a practicing attorney, I spent about 10 years doing legal aid type work, and we did a lot of wills and living wills and powers of attorney. When we were doing a power of attorney, I really wanted to document four things: that the client knew that they were naming an agent, somebody to act on their behalf; that the agent could bind them to decisions. The consent of the agent is the same as the consent of theirs; that they could revoke that appointment at any time. If they changed their mind, they could say, I don't want that person to be my agent anymore. We could revoke the document. And the general nature or authority of that they're delegating. And we'd go through a list of powers, and I'd try to make sure that they understood what the person could do and the limitations on that. So capacity to do a power of attorney, we actually incorporated those elements into the interview checklist, the interview format that we used for creating powers of attorney, a similar one for wills, where if the client could answer the questions that were on there, we had their answers written down, and that would give us backup should we ever have a challenge on whether the person knew what they were signing at the time they sign it. Contractual capacity, courts generally assess a party's ability to understand the nature and effect of the act of business being transacted. The more complicated the business, the higher the level of understanding. Most of us are pretty clear on all of this. And then I remember a reverse triangular merger in corporate law. Somebody'd have to spend some time explaining that one to me again. I remember being able to get the answer out on an exam in law school, but some of the stuff gets really complicated, and the ability to understand it, the necessary skills to understand it, change with the complexity of the transaction that's being done. Capacity to convey real property, and we see challenges of transfers of real property based on a lack of capacity. The person didn't know what they were doing. So to execute a deed, the grantor typically must be able to understand the nature and effect of the act at the time the conveyance is made. What does that mean? They're transferring their rights to in the property to someone else. Generally, they no longer have the right to use or occupy the property, and they're not able to reclaim it. In most situations, this is not cancelable. They can't change their mind and take it back. If I were doing deeds or transfers of real property or leases, I'd want to ask questions that generated answers that verified to me that my client understood those three elements, and I'd want to put that in writing as a part of my file. So if a challenge came up on down the road of, did the person know what they were doing when they signed that deed or that lease, my file documented that my client was able to understand those elements. If capacity is not stated, if it's not defined in a case or a statute, do they understand the essential elements? Do they understand that there are options available, the consequences of the choice that they're making, and are they able to make a choice? It is rare. There are some forms of dementia where people just simply can't make a choice. A client of mine from many years ago stands out very vividly. Electric bill was laying there, checkbook was laying there. She'd write the check and put it in the envelope, and she couldn't decide whether she should mail it or not. And her bills went unpaid because she couldn't make a choice on something that was really very simple, despite the fact that she knew she had an electric bill and she knew she had a checkbook and she knew she had money in the account. She couldn't make the connection between those elements of, I need to write a check and put it in the mail or they'll turn my lights off. Case example, we're going to talk about Edna and Bill. Edna and Bill have been married for 62 years. They arrive for your meeting and Edna does all the talking, saying that they want to leave everything to each other, and when the second one dies, in equal shares to their three children. Edna wants to be named as the agent and power of attorney and healthcare surrogate for Bill, for her husband. For her power of attorney and healthcare surrogate, she wants to name their oldest son. When you ask Bill what he wants, he says, whatever Edna says will be fine. You ask Bill the names of his three children, and he responds, ask Edna. You ask him what bank their life savings is in, and he turns to Edna and says, you know that, don't you? So what are the red flags? What are the caution points here? A, Edna speaking for both of them. Is that a red flag? B, Edna's choice of her agents. She didn't choose her husband. She chose one of her adult children, which means maybe she's concerned about either the choices he would make or his ability to make choices. His bills deferring to her and his inability to answer basic questions. All of those are caution flags, red flags that maybe Bill has issues with memory capacity, cognitive ability, and maybe he doesn't. Maybe he's just simply decided it's easier to go, whatever she wants will be fine, whatever she wants will be fine. But you need to take some time and ask him some questions and engage him in a conversation so that you're comfortable and confident that he knows what the decisions and choices that are being made. Or not, and if not, then you need to be careful about what you do. This would be even more alarming if they'd only been married for 18 months and there was a 40-year age difference between the two, and the wife was speaking up and saying everything that she wanted done for the husband and he was saying whatever she wants will be fine. Then you start to worry not just about capacity but also about undue influence and other concerns. And working in this field, you will see those interesting situations. So what do the model rules for professional conduct say about capacity? Pretty picture of two eagles that was taken about 1.5 miles from where I live a few months ago. Capacity in and of itself is not defined in the model rules of professional conduct. Informed consent is, and informed consent kind of moves us in the right direction. It's in a section called terminology, model rules of professional conduct, point 1.0 terminology. Informed consent denotes an agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks and reasonably available alternatives to the proposed course of action. So we need to talk about risks. We need to talk about available options or alternatives. And we need to do that in a way that the client can understand. And here we come to 1.4, which is communication. A lawyer shall keep a lawyer reasonably informed about the status of the matter and explain the matter to the extent reasonably necessary to permit the client to make informed decisions about representation. Again, capacity is not really defined, but that communication clause, part B there, explain the matter to the extent reasonably necessary for the client to make informed decisions, combined with informed consent, gets us really close. And a decision needs to be made because capacity is really about decision making. Legal capacity is really about decision making. And Rule 1.2, the scope of representation and allocation of authority between the lawyer and client, states very slightly in the wording on this one, but they all have the client making some decision generally about the goal or objective of the representation. The model rule says that we shall consult with the client by the means by which that should be pursued. But the client actually makes the decision regarding the objective or the goal of the representation. And if you put all of those together, a client has capacity if they're able to communicate in a way that the client can understand to the degree necessary for the client to give informed consent regarding the objectives or goals of the representation. And if not, the client has diminished capacity. This is a slide I actually edited yesterday afternoon when I was going back through here from not the client lacks capacity, but the client has diminished capacity, because we're starting to really understand that as long as a person can communicate, they have some capacity. So if they don't meet that entire standard, we're going to say they have diminished capacity. And then the rules give us, the model rules give us some guidelines on a client with diminished capacity. And this is in Rule 1.14. And the most important, or really the leader in, is a lawyer shall, as far as reasonably possible, maintain a normal attorney-client relationship with the client. They are your client. They're still your client. You owe them all of the ethical duties and responsibilities that you owe any other client. Over the course of the work that I did in legal services, we took on a lot of clients that we knew up front had diminished capacity, and had that strong attorney-client relationship with that person. Part B of the rule says that if the lawyer reasonably believes that the client has diminished capacity and is at risk of substantial physical, financial, or other harm, states vary in how they word that sentence, unless action can be taken, and that the client is unable to take action to protect themselves, that the lawyer can, including consulting with individuals or entities that have the ability to take action to protect the client. The last phrase, the last clause in this sentence, in appropriate cases seeking the appointment of a guardian ad litem, conservator, or guardian, is one where you get on the thin ice as a lawyer. If you become guardian or conservator of your own client, you're entering into ethically very, very difficult territory. If you think a guardian or conservator needs to be appointed for your client, you're much better off asking somebody else to file and somebody else to serve as guardian or conservator of the client. A lawyer who ends up as guardian or conservator of their own client. There are people who do it and do it all the time, and they're really good at it, and they really understand the ethics rules. But the average practitioner, family law practitioner, estate planning practitioner who's not a specialist in that area, it's a really thorny ethical issue. And when you go read the attorney discipline cases on 1.14b, most of them are attorneys who meant well but didn't comply perfectly. So I really caution people on that particular one. The comments to Rule 1.14 really are much more informative than the rule itself. And comment one and the sentences that I've underlined are ones that I thought were particularly important. Nevertheless, a client with diminished capacity often has the ability to understand, deliberate upon, and reach decisions about matters affecting their own well-being. Someone with early to mid-stage dementia is going to have a lot of ability to do this. Someone with mental illness, especially a treated mental illness or a developmental disability, with a lot of support and explanation, can make a lot of really good decisions. It's important to recognize that age is not the factor. Ability to understand and communicate is the factor that we're looking for here. So persons of advanced age can be quite capable of handling routine financial matters, but may need special legal protections regarding major transactions. The more significant the transaction, the more concerned we should be about whether the client has capacity or not. The fact that a client suffers from a disability does not diminish a lawyer's obligation to treat the client with attention and respect. If you read the discipline cases across the country, you'll find cases where lawyers fail to do that. The client may wish to have family members or other persons in discussions with the lawyer. And this happens, and there is a concern about evidentiary privilege. And if you're concerned about evidentiary privilege, you need to make sure that the presence of that third party is essential or necessary to facilitate communication and understanding with the client. Otherwise, it does become an attorney-client evidentiary privilege issue. Remember, confidentiality applies to everything you know about your client, no matter where you learned it from. You could read it on the front page of the Washington Post, and you can't talk about it if they're your client. It's also important when there's third parties there to make sure that you're working to the client, looking to the client, and not the family members or friends or others when it comes time to make choices and decisions. And lawyers and other professionals sometimes forget this because it's so much easier to communicate with. It was so much easier to communicate with me than it was to communicate with my mother, who had dementia late in her life. But ultimately, it was her life and her choices that needed to be made. Comment 5, an excerpt from this. One of the actions that a lawyer may take is consulting with family members, using reconsideration periods to permit clarification or improvement of circumstances, voluntary surrogate decision-making tools such as powers of attorney, consulting with support groups. I was conferring with someone this morning and suggested that they contact Adult Protective Services to get some guidance and some information, some screening and evaluation. And in taking protective action, it's important to make sure that we honor the wishes and values of the person, the client's best interest, with the goal of intruding to the least extent possible into the autonomy and dignity of the individual, maximizing their capacity and respecting their family and social connections. And there's a lot of push right now, and we're reading legislation around the country about visitation and family and social connections that people are that have popped up in the news as problems, and we're starting to see some legislation on that. If we look at those slides from Rule 1.14, what do they look and sound like? They look and sound like supported decision making. These are supports or services that help people make their own decisions by using family, friends, trusted professionals, people that they trust. Every time a lawyer is counseling a client, we're helping that client understand, ask questions, receive information and explanations in language that they can understand, and make and communicate decisions. Lawyers are the ultimate example of a decision supporter. We practice supported decision making as a routine part of what we do on a day-to-day basis. If you'd like to explore supported decision making in more detail, the practical tool for lawyers, Steps in Supported Decision Making, is available for free download off the ABA Commission on Law and Aging's website. And the National Center on Law and Elder Rights has several archived and recorded webinars on supported decision making, and I see a note in the chat that you have a supported decision making webinar coming up sometime next week. Good. So how do we go about assessing capacity? We do it every time we communicate interactively. Now, this is a kind of a one-channel. I don't know whether you're understanding me and hearing me or not, but understand if when we're communicating interactively, we're asking questions, we're listening to answers, we're assessing capacity, because our brain is subconsciously looking for mutual understanding, and when it's not there, then we become concerned about capacity. There's no simple test. Don't try the answer these 20 questions and we'll know and score it and we'll know whether we have capacity or not. Even professionals with decades of specialized training view those simply as screening tools and not as definitive determination of someone's capacity. Look to the totality of the circumstances, the client's ability to communicate and give informed consent. And when in doubt, if you're really worried about capacity, seek guidance, refer for a professional outside evaluation, talk with other professionals, and seek some guidance if you're in doubt before you proceed. Lawyers need to make an independent judgment on legal capacity unless there's a court order in a guardianship or conservatorship case that says this person lacks capacity or has diminished capacity or limited capacity. The lawyers need to make an independent judgment on legal capacity. It's essential that we meet with clients privately and individually, because like in the Edna and Bill situation, if all you do is listen to what's going on and you don't pursue the fact of whether the concerns about whether Bill can answer questions or not, you may never get to the point of whether he really knows what he's doing. Capacity is complex. Often multiple meetings help assess the client's ability to understand and make informed choices. While other professionals also make determinations of capacity, only a court order restricts or modifies legal capacity. Naming an agent and a power of attorney doesn't. A guardian or conservatorship appointment does. Healthcare professionals generally make a determination of whether they believe their patient can give informed consent or not, and that's fine for healthcare. But that doesn't mean that that same client can't sign a power of attorney or name a healthcare surrogate or initiate a divorce proceeding. The lawyer needs to make an independent legal judgment of whether they believe the client understands the legal transaction sufficiently to make choices and enter into those decisions. We have published the Handbook for Lawyers, Assessment of Older Adults with Diminished Capacities. The second edition of it is actually now available for purchase on our website. They'll start shipping in 2 or 3 weeks. The first edition was published about 15 or 16 years ago, and there have been a lot of advancements over those 15 or 16 years. But the second edition is in the process of coming out. The book will urge you to develop a process meant to structure and record observations. It needs to be systematic. It needs to be accountable and documented. I'm a huge fan of standardized intake and interview templates. And you use them with every client and they become a part of the client file, whether it's an electronic file or a paper file that asks a set of questions that if the client is able to answer those, help you to document that the client knew who they were, what they wanted to do, why they wanted to do it, that satisfy the essential elements of making you comfortable and confident that the client had capacity and knew what they were doing. The handbook has an assessment checklist in it, and this is actually a draft from the updated checklist that's in the second edition of the book that's just coming out. It starts off with looking at cognitive functioning, brain function. Short-term memory. Short-term memory is generally affected before long-term memory, and problems with short-term memory are reflected by people who repeat questions frequently, forget what was discussed within 15 or 20 minutes, can't remember events or past days. And there are informal ways of asking about this. You know, what did you do last weekend? When was the last time you went to see a movie? When was the last time, when did you know, what are you doing for grocery shopping? There are informal ways of asking some of these things, but you'll also find with folks that are experiencing a decrease in capacity that they'll repeat questions and they'll forget in the course of the conversation as it's going on. Language and communication problems, difficulty in word finding, is a sign of changes in the brain. Now, we all experience this to some extent, but it'll become more profound as the person's memory and as the person's cognition starts to become problematic. Vague and disorganized language, difficulty staying on topic, bizarre statements or reasoning. If it weren't for attorney-client privilege, the book that I could write about some of the answers that clients gave me over 9.5 years. Difficulty using phone, email, or other forms of communication are signs of language and communication problems. Comprehension problems. Difficulty understanding or repeating simple concepts, again, repeating questions. A lack of mental flexibility, difficulty comparing alternatives. There's 2 different options or 3 different options, difficulty comparing those, difficulty adjusting to changes. Disorientation, trouble finding their way around your office. They get lost trying to find your office. They get parked in the parking lot and they can't find the door to come in. Also confusion about day, time, year, and season, although a lot of people have been disoriented this last year because the normal hallmarks that appear in our lives about where we're at and what season it is have been absent for a lot of us. Financial management abilities. This is a new section. If you're familiar with the handbook and the checklist that was in it in the past, this was added. Problems with everyday arithmetic. And this is, how are you going to assess this? Because you're really not going to be doing a test. You're going to need to ask about questions or talk with other family members to see, do they have difficulty with basic math, calculating a tip in a restaurant, decreased of understanding of financial concepts, healthcare deductibles, interest rates, liens, joint liability, decreased comprehension of ordinary financial documents. I spent about 2 hours one afternoon with a neurologist, neurologist who works in this field, trying to describe all of the decisions that need to be made to pay a bill. And there are an incredible number of decisions and calculations that need to be made, but difficulty with paying bills on time. And not paying bills on time is really the canary in the coal mine for a lot of folks, that they're experiencing a decrease in cognitive ability and memory. Diminished awareness of financial risk. People with diminished capacity enter into risky investments and make decisions that they would not ordinarily have made. Emotional functioning, and we're going to have clients that are tearful, anxious, excited, pressured, manic, and emotional distress. It can, especially if it's not related to a trauma that's going on in their life. can be a sign that there are changes in cognitive ability. And emotional lability moves quickly between laughter and tears, or feelings that are inconsistent with a topic. Feelings that are inconsistent with a topic, laughing at things that are tragic, crying at things that are funny, is actually a symptom of particular causes of dementia. With dementia being a decline in cognitive ability and memory, there are some particular uh, physical causes of dementia that frequently result in feelings that are inconsistent uh, with the issue or topic that's going on. Behavioral functioning delusion. Somebody's out to get them. People are spying on them. People are doing bad things against them. Fearful and unsafe is a symptom of can be a symptom of dementia from several causes. Hallucinations. My mother had Parkinson's disease and developed related dementias, and my parents weren't my clients, so I can talk about them without breaching attorney-client privilege. She had hallucinations, and we really didn't at the time didn't understand what was going on, but it was very, very real to her that her mother had come to visit that afternoon and sat in the chair across the room from her and stared at her and refused to talk to her. And we had to validate that it was real for her, but it wasn't real for the rest of us. So hallucinations and delusions are usually kind of mid to late stage dementia, but they do pop up. Poor grooming and hygiene, and I always caution with this that some of us have always been slobs, but dressing, showering, bathing, shaving, dealing with one's hair become difficult because there are a surprising number of cognitive functions that are involved in that process, and also the physical processes of bathing become difficult with age, and they can be a warning sign that something is changing, something's gone wrong. Markedly inappropriate social behavior. There are some forms of dementia that result in a loss of inhibition. I had a grandmother who chased the good-looking men down the hall in the nursing home and pinched them on the behind. And she'd always been this ultra conservative, quiet, never said anything out of space in her life. She'd never, I think my grandfather was the only man she ever kissed. And yet, as her dementia progressed, that loss of inhibition kicked in, and it was interesting to see. Other observations and notes from third parties, and notes from third parties has been added here. You'll frequently get a call or a referral of mom is having a problem with, or I think this person is experiencing. Make notes about that and compare your observation, your conversation, your communication with the client with what you've been told. Because if others are concerned, there may be a good reason for it. And if you're dismissing that, you need to be able to document I asked enough questions and I'm sure that we don't have a problem. And also potential screen for undue influence, and we'll talk about undue influence in a moment. Mitigating or qualifying factors that affect the observations. And we talked about that list a few minutes ago of medical factors, time of day, hearing and loss. This is a new one that we've started to look at. Hearing and loss, and also language, especially if the person's first language is not the language you're communicating in, can be misinterpreted as a lack of capacity or a diminished capacity. The new version of the handbook has some good tips for dealing with vision and hearing. Social factors, um, educational, cultural, and ethnic biases. We've become aware over the last decade of the impact of unconscious or implicit bias in capacity evaluations. There's an increasing awareness in psychiatrists and psychologists and neurologists who do assessments that a lot of the standardized testing instruments or tools that they use are not culturally normed and may not be appropriate. An example that someone gave me recently was a math question that if you were a high school graduate, you should be able to answer, but if you were a high school graduate in a segregated Southern school 70 years ago, you didn't have algebra. So that simple equation that, oh, everybody should be able to answer was a loss to that person because of the educational background and basis that they had. What are the tasks that we're looking at? Because again, it's task specific, notes on the client's understanding or appreciation of those elements and functioning. The more serious the concern is about some issues, the higher the functional ability that's needed. Is the decision consistent with the client's long-term values and commitments? If not, can the client articulate reasoning for the changes? So if somebody comes in and they're going to change their will from equal share to all 4 kids to my daughter is getting every penny and my sons aren't getting anything, is there a good reason for it? The decision is objectively fair. Will anybody be hurt? And again, this is one of those issues where there's a growing amount of litigation for estates and for financial exploitation. And lawyers are often a tool or involved in that. So if the decision is going to be objectively unfair, you need to be able to document that the client understands why and what's happening. Is the decision irreversible? Property transfers, big one. Transferring things into irrevocable trusts can't be undone. Do they understand the irreversibility of some of the choices that they might be making? There's kind of a summary sheet of, I didn't have any concerns. I have mild concerns. I have more than mild concerns. I have severe concerns. My bottom line piece of advice on capacity is if you're really not comfortable about it, don't do it. Better to turn the client down and say, it was really nice meeting you, and I think you're going to have a wonderful life and everything's going to be fine, but not do anything. And those aren't always easy decisions to make, but sometimes they're the right decision to make. There's a box for some summaries. Undue influence, and I've got about a couple of minutes more material, and then we want to do a few questions. Is the use of power and control to exploit trust, dependency, or fear to substitute one person's will for the true desires of another for the purpose of gaining control. It's a little bit expensive, but there's a really great book on undue influence that was published this last year. There's 3 related topics: financial exploitation, undue influence, and fraud. Financial exploitation is the taking or unauthorized use or taking of money or property of a vulnerable adult for the benefit of another person. Every state defines financial exploitation in their adult protective services laws. Undue influence is the exertion of influence over a vulnerable adult with the intent to override or change the choice or free will of the person for the benefit of another person. Fraud is a theft always involving an intentional lie or misstatement of fact with the intent that the person will rely on that to the benefit of another person. Condensing that down into a simple chart, financial exploitation requires vulnerability. Every statute requires vulnerability, and vulnerability may be defined in your state statute as just simply over the age of 65. Some states do it purely by age. That does not require a person in a position of power or influence. It does not require an intentional lie or material misstatement. It just requires a vulnerable adult and the theft or the use of money or property for the benefit of another. Undue influence requires vulnerability, but you must have capacity because we're overriding the capacity of the person. We're getting them to change their decision from the decision they would normally make. So they must have the ability to make some decision. Undue influence requires a person in a position of power or influence. It does not require an intentional lie or material misstatement of fact, and it involves the theft or the use of money or property. The most common undue influence one we see is, if you don't give me what I want, I'll drop you off at the nearest nursing home and you'll never see your grandchildren again. True statement. And billions of dollars are stolen with those two lines. Fraud requires an intentional lie or misstatement in the intentional theft or use of property, but does not require vulnerability or a person in a position of influence or power. If you're looking at the cases, it's important because lawyers get hung up on words. Think through the elements of what's required, what's optional, pleading in the alternative of maybe it's financial exploitation, but maybe it's undue influence, but maybe it's fraud, but maybe it's lack of capacity, gives your opposing counsel lots of grounds for defense of, well, you don't really know what it is. If you plead fraud and undue influence and you don't have a material lie or material misstatement of fact, you're going to lose on that cause, and frequently at that point things just simply fall apart, despite the fact that the undue influence might still have been there. There is a screening tool for this. California Elder Justice, if you just simply put California Undue Influence Screening Tool into your favorite search engine, this will pop up. It's modeled based on California's law, so you may want to make some adjustments to it, but it actually has a set of checklists of indicators for the factors of, is there vulnerability, is there authority, is there an action or something taken to try to influence the person, and is there an unfair equity or result? Does the person does somebody else benefit from it? Important in the model rules of professional conduct, don't be an enabler. If your representation will result in the violation of the rules of professional conduct or the law, you shall not represent or shall withdraw. Permissive withdrawal, if it can be accomplished without material adverse effect on the interest of the client. If the client persists in a course of action involving the lawyer services that you believe is criminal or fraudulent, or the client has used their services to perpetrate a fraud or a crime. This comes up a lot where the kids have you preparing a power of attorney for mom and they plan on using it to steal her house. Not steal it, transfer it for their benefit. They're going to commit financial exploitation. You've got the option to withdraw there and to say, this is a bad idea and I'm not going to be a part of it. Questions?
So thanks so much, everyone. Please type any questions you have in the chat. I'll start with one. So David, you alluded above in terms of a shift in thinking over the past 20 years and the language that we use to describe older adults, how we think about capacity. Can you talk about more of that evolution of thinking and how that's permeated elder law?
Yeah, there's a few things that have really changed. The emergence of supportive decision making and the concept of decision supports, and the recognition that every adult seeks help with making some decisions or choices in their life. And I'll use myself as an example. The last time I replaced a faucet, I flooded a house. I don't do plumbing. So if I have a plumbing problem, I need to call in somebody who knows more about plumbing than I do, who I trust, who's going to explain what the problem is, what the options are. They're going to make a recommendation, but I'm going to make the choice. And if I apply that standard across the spectrum of capacity, the issue is not whether the person needs help in understanding the issue, the options, the risks and benefits, making a choice, understanding the consequences of the choice. The issue is the spectrum of issues the challenges, the spectrum of issues that we need support on. So supported decision making leverages residual capacity to allow people to make a broader spectrum of decisions. And that's really been a huge emerging one. There's been a vast change in understanding of dementia over the last 15 years. Recognizing that not all dementias are the same. Alzheimer's is the most prevalent cause of dementia, and Alzheimer's has a specific way that it impacts the brain from a structural standpoint. But there are other causes that result in dementia, and they impact the brain differently. They change your abilities, your decisional abilities, your emotional reactions, your communication in different ways. And recognizing that has changed. There's been a lot of research. Two different researchers that I've worked with have done a lot of research on financial decision making and starting to understand how incredibly complex what we think of as simple really isn't. I was watching somebody sent me a video clip earlier this afternoon. Boston Dynamics has made a robot dance. They actually have 3 or 4 different robots, and they have them do a dance. You can go on YouTube and find their dancing, but Boston Robotics dancing robots clip. It took years and millions of dollars to understand the measurements and calculations that are necessary for a robot to stand up and walk and dance. Our brains do that all the time. And when we're looking at capacity and we're looking at decision making, our brains do incredibly complex things. And there's been a wealth of understanding and growth in the understanding of that. And how that impacts then the communication and the choices that we're making.
Thank you. I watched an ABA webinar on guardianship, and they talked about the shift in the model legislation from ward to respondent, which I thought was also just a representation.
Yeah. Well, and if you go back before Ward, it was lunatics, asylees, habitual drunkards in the 1800s. So there's been a real shift in our understanding, and it's a person in need of protection, not a person who's disabled, but a person who's in need of protection is what's in the Model Act, which is really a good way of thinking about it.
Definitely. Could you talk about the role of doctors? I know in guardianship proceedings, you typically need people to sign, other professionals to sign off, but when you're an attorney and you're working with someone who doesn't have a lot of money, you can't really pay for that kind of assessment. So do you ever avail yourself of the help of doctors, or?
I worked in a legal aid program. We did a lot of basic estate planning, basic wills, living wills, which were our advanced healthcare directives and powers of attorney. I had a handful of professionals there in town, a couple of psychologists who would help me out. If I was really concerned, I could talk to my client and go, would you please go see Neil? He'll talk with you for a few minutes. And I just want to make sure that I'm understanding you and you're understanding me. And if we get another opinion on this, it'll help us to make sure that we're understanding one another. And they do it on a volunteer or pro bono basis and work the person in. We had some incredibly talented social workers. I had a close working relationship with Adult Protective Services and local social services agency, and they had some incredibly well-trained and talented social workers who would help. And I also had some really well-trained folks with the local hospice program, and I did volunteer work for them. So if I needed their help on something, they'd help me out because they knew they could call on me and I'd help out their clients or patients. So we did work back and forth on that. Also with screening for undue influence, one of the cases that stands out in my mind, I really thought the person had capacity and knew what she was doing, but I thought she was being unduly influenced and I refused to do it. And that was one that ended very badly. And I was very sad that it ended badly, but glad that I didn't enable the people who were going to hurt her.
Those are great practice tips, making connections with those professionals in your community. Thank you. Well, thanks so much. I'm not seeing any questions from the chat. So if you wouldn't mind, David, just going, I have a few slides about our organization. I think we have some attendees from all over. So you can follow us on social media. Go to the next slide. We have staff attorneys here, but the majority of what we do is connecting people who need legal services and don't have a lot of money in Maryland to volunteer attorneys. So we have a pro bono portal. You can look at people's stories and decide to take a case. If you go to the next slide. And that's what our pro bono portal looks like. The cases are categorized. Go to the next slide. We also have a ton of trainings coming up. And, oh, thanks so much, Jack. We do have one question that we can end with. One training is not here. On the 15th, we have I think a great follow-up to this training. It's on supported decision-making. And some of these are about Maryland law, but a lot of them are not. So you can also go to our website and see if anything appeals to you.
Okay. And
let's see. Oh, thanks so much. Are you able to see the question? Okay, great.
Yes. And the question was, is undue influence and financial exploitation. And it's kind of a typical fact pattern of one sibling took probably a parent or mom or dad to another state, got them to change their estate plan. They died in that state, and the person who had taken them received all of the assets. What happens there is probate litigation, and that's a vastly growing area of litigation. Unfortunately, it probably needs to be done in the state where the person died and where the new will was done and the estate was done. And the challenge would be based either on lack of capacity or on undue influence. And that is a rapidly growing area of probate litigation. And there are time limits on getting that done. They're really very, very time sensitive. Once the estate is closed and final, the statutes of limitations can make that really, really difficult. But I would urge that family to consult with attorneys in the state where the person died about the options for challenging the disposition of that estate, either based on undue influence or lack of capacity or some combination of the two.
Thank you so much, David. And thank you again for all this helpful information. I'm really excited about that new edition of the handbook. It's got great information. I really appreciate your time today. And thank you all the attendees for tuning in.
Thank you.
Thanks so much again. This recording will be up on our website, and I'll also email it to all of the attendees today. Thanks again, everyone. Have a great afternoon.